Hey, what's up, guys? Whoa, what is happening? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And with me today is this caller is not, I don't know what's going on. Just a shoddy polo shirt that I took a nap in earlier. I guess it's ruined. Whatever. Anyway, that's going to be distracting. I am going to have to fix that. I don't know. I don't even know what's wrong with it. What is going on here? Oh my goodness. Oh. Anyway, my neck feels old. Do you guys look at yourselves for hours a day? I mean, I do. It's horrifying. Anyway, hey, what's up, guys? Welcome to a new week. A new week of what's up? Put the collar up and say blah blah. A new week of the world, of all sorts of stuff. It's gonna be a shorter week for me. This week I will not be doing a show on Thursday night, and from Friday until the next Thursday, I'm not positive on how consistent the shows will be. Because I will be taking my family to Disney, and so on that vacation, I'm not 100% sure on how many full-on live late shows there will be, because of the nature of hotels and all of that stuff. It's going to depend on the internet and the ability for me to do that show without ruining everybody else's trip. So, that is, we'll see. I am bringing a streaming setup. So hopefully there will be adequate internet and ample time to do some shows. But I will keep things posted on Twitter and on the YouTube community page to keep everybody updated with that. So I will also try to release some short videos on my trip as well to make sure that there is fresh content coming on the channel. So yes, we'll also go to Universal. I know. I got it. We're going, when I say going to Disney, we're going to Orlando. We will be going to all sorts of ridiculous things, and my bank account will be plummeting into the negative as fast as humanly possible. I've already made peace with it, and I've mortgaged my own soul to Walt Disney, also known as Satan, for it. So there we go. So anyway, it's going to be a disaster, but it'll be a fun disaster for the kids. I didn't lose my Twitter. It was just a 12-hour ban, which I thought I made that clear, but it was a 12-hour ban. But my Twitter is fully operational and should remain so. Beware of Florida man. Yes. So today we're going to be talking through this case that I started covering a long time ago. And in the hubbub of the Vic case, and also just the sheer amount of filings in this case, there are 200 filings in this case, and most of them are pointless. Most of them are absolutely pointless. But this is the case. It's the state of Washington et al. Versus the United States Department of State et al., which is the U.S. Department of State, and the et al. Is Defense Distributed, which is headed up by, or was headed up by, Cody Wilson. No longer is headed up by Cody Wilson. It's the company that, they do a couple things. They make the Ghost Gunner, which is a mini CNC mill that is automated. You can mill out lower receivers with it, or it will do it for you, so to speak. The other thing that they do is they distribute CAD files for 3D printers and for automated CNC machines. Those CAD files are to create the parts you would need to make a firearm, either a 3D printed or a home milled firearm. They distributed those files, and that was apparently a no-no. They were not allowed to do that. They couldn't have that speech because of this import-export law. Now, never mind the fact that Corona, I have not decided on whether or not to do that, so I'm not going to make that announcement. Oh my goodness, you killed my train of thought. Ban yourself. So it was a no-no because there's an import-export law, and it doesn't matter that they said that they would limit, the distribution to just inside the United States or whatever. I guess the U.S. justice system was coming after Defense Distributed and Cody Wilson. Now, this was before Cody's other issues in the state of Texas. So as they were coming after them for what they were doing, they had a long back and forth in court, and then they reached an agreement, a compromise, and that was that the United States would actually change the import-export laws to take this off of the list. And it wouldn't really be a law change. It would be an understanding of what fell under the law. They were going to remove these CAD files, okay? We'll probably get to some of this background in the document, but this is the high-level overview. They were going to remove this CAD file, and then that would nullify the criminal charges and all of that. It was going to go away. Well, I mean, consent between party one and party two is not fine if the cuck in the corner doesn't consent, right? And in this case, the cuck in the corner is 21, I believe, attorneys general of various states, and then one city attorney of, I think, Los Angeles. They did not approve of the government's arrangement with Defense Distributed, and so they sued in a baffling court case. It is the idea that they would have standing to sue on this is questionable at best. It's a weird sort of thing, but they have won. They have won, and we're going to look at why. And part of the reason they have potentially won, although I don't think it would have made a difference, they will point out errors on the side of the State Department and errors on the side of Defense Distributed's counsel. And when I say errors, I don't know that they are errors, but the court has called them out as errors. And so unless the appeals court overturns it, then we're stuck with this decision. But now apparently the criminal case is back on the table, even though the U.S. government doesn't want to do it. So that's weird. It's a really strange decision. It's a really strange case, and it's a really strange outcome. So we're going to go through that today in just a minute here. But first, there are a couple chats to address. Distract Enemy says, "Hey, Nick, I need advice/help with a legal issue my family is having with an HOA. They've called the cops on my family, trying to get our dog killed, and a whole host of other stuff. I sent an email with some info. I will give it a look. I saw an email come by earlier, but I haven't had time to read it all. It was a longer thing. But I'll take a peek." Oh no. What are you doing? What? You need to go back to bed. We're going to put this back on. Okay. Okay, you are causing trouble here. Whoa. Yeah, I know. Now, look at me. Look at me. I love you. Good night. Go to bed. Anyway, yes. So there we go. All right, we've got Paul Godin says, with all those expenses, you better up your grifting game. Yes. No, thank you. I appreciate it very much. The Gentleman Sausage says, here's $20, enough for half of one overpriced Disney pin on me, buddy. Oh, thank you. I appreciate it. Gelt Walker says, gifting the Lord of Grifters so he can at least pretend to get us something while there. Maybe some new Mickey Mouse Grandpa shorts. There you go. Maybe I'll read a horrific criminal sexual assault case as Mickey's voice for you guys. Maybe that'll do it. Oh, you know what? Someone sent me a gift today. I got 2 gifts today, but one I'm not allowed to open until I discuss it with the gift giver. So that one I'm not going to talk about yet. But the one I did get is someone sent me Emotional Intelligence 2.0, which was the remember that was the Ron the Ron suggestion. And yes, Ronversations will finish. Don't worry. Well, we'll continue. Who knows? Ron DM'd me once the other day, but he hasn't responded to me when I replied. So don't worry. That will, we'll catch up on Ronversations before I go. So that will happen either tomorrow or Wednesday. No worries. The Ronversations will not cease just because of a silly trip. But yeah, so don't worry about Ronversations. That was some nobody said Ronversations though, you fathead thumps. Don't worry, Ronversations will resume. Beatings will resume until morale improves. So and then Mirnum 007 says, here's a bit for a pair of Sprox from Galaxy's Edge. I don't know what that even means. What's a pair of Sprox? So will I address the rumors by the truthful members of Kick Vic that your children are fake and part of the GoFundMe grift? Yes, they're right. Whatever they've ever said is correct. So that's it. It doesn't say Sporks, it says Sprox. Click on it. It says Sprock. I mean, I know what a spork is, but I don't know. Maybe it's something different. So, anyway, here we go. Okay, so let's get into this thing, shall we? This weird order here. Here this is. And God, this is just whew, lads. This is great. Because remember, the reason there are 200 filings, in all honesty, in this case, is because almost all of them are related to applications for appearances pro hoc vice. Because you have 22 idiots with staff, all from different states, fighting this fight. It's great. It's fantastic. And everybody hates it. So anyway, but here it is. So State of Washington, plaintiffs versus U.S. Department of State, defendants, blah, blah, blah. So we're going to just take a glance through this. This is, like I said, this is a weird case. You won't see much like this. These are states suing the federal government and a private company, okay, combined, over their plea agreement, basically, on federal criminal charges about an import-export law which restricts the sending of certain documents from inside the United States out of the United States, alleging that allowing them to do this, to distribute the files outside of the United States, will damage and has damaged and will continue damaging these particular states. Okay? That's the rundown of this case. You will not find many lawsuits like this. It's absurd. Okay, this matter comes before the court on the parties' cross motions for summary judgment. That's docket number 170, 173, and 174. We're not going to read those. That would take like several shows. Plaintiffs seek a summary determination that the federal defendants violated the Administrative Procedures Act when they modified the United States munitions list and issued a letter authorizing the online publications of certain computer-aided design data files in July of 2018. They request that the court vacate the agency action and permanently enjoin the federal defendants from removing the CAD files at issue from the USML unless and until they comply with the statutory procedural requirements. Okay? So this is great. Background and procedural history. Since at least 2013, the federal government had taken the position that the Arms Export Control Act authorizes restriction on the internet publication of CAD files that allow users to create guns and their components with a 3D printer. When Defense Distributed posted CAD files for various weapons on its website at the end of 2012, the Directorate of Defense Trade Controls, there's a lot of acronyms in this filing, which is part of the Department of State, notified Defense Distributed that the publication may have been unauthorized and in violation of the AECA's implementing regulations, the International Traffic in Arms Regulations. The DDTC explained that making the CAD may have been in violation, may have been unauthorized and in violation. They don't even know because the government doesn't actually know whether or not you violate its laws. This is, I'm not joking. This is a common thing that governments don't know when you violate the laws or not. Well, like you maybe did. We should probably send it to, wait, what? The DDTC explained that making the CAD files available on the internet constituted a disclosure or transfer of technical data to foreign persons and was considered an export subject to the AECA and ITAR. The government advised Defense Distributed to remove the files from its website and, if it believed the files were not properly subject to export control, to utilize the commodity jurisdiction procedure to obtain an official determination from DDTC. Defense Distributed filed a number of determination requests. When the DDTC failed to make timely rulings, so here, look, your stuff may be in violation, so we're going to advise you to take it down and then follow this government procedure to go ahead and figure out if it's okay. They follow the government procedure. The government doesn't do their job. Shocker, I know, but don't worry. Your taxes went up every single year. Defense Distributed filed a lawsuit in the U.S. District Court for the Western District of Texas. That litigation pitted Defense Distributed and the Second Amendment Foundation on one side against the Department of State, the DDTC, and various federal employees on the other. Defense Distributed challenged the federal government's power to regulate its publication of the CAD files on the internet, arguing that the regulation subjected its gun-related speech to a system of prior restraints that was applied in an arbitrary manner in violation of Defense Distributed's First, Second, and Fifth Amendment rights. A month after the Texas litigation was filed, the DDTC determined that some, but not all, of the CAD data files Defense Distributed wanted to publish on the internet were technical data subject to the AECA and ITAR. So they waited until they had to file a lawsuit, and then a month later decided, oh, well, yeah, these are subject to that. Defense Distributed filed a motion for preliminary injunction in the Texas litigation to preclude the federal government from imposing pre-publication approval requirements on any of its CAD files. The federal government opposed that motion, arguing that export of defense distributed CAD files would cause serious harm to the United States national security and foreign policy interests that warrant subjecting the files to ITAR's export licensing of technical data. Now, this is if I know what's going on here, this is a real garbage move by the judge, because they settled these claims. That's what this is about. This case is about the settlement that the states are not happy with, all right? So what the judge is doing here is using the arguments from the case that was settled and resolved out, I believe. We'll find out in a second when he says, now this case was settled, blah, 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 but here are the arguments. Like, but they didn't raise those arguments in this case, and that's pretty lame. Let's see. Defense distributed CAD files constitute the functional equivalent of defense articles capable in the hands of anyone who possesses commercially available 3D printing equipment of automatically generating a lethal firearm that can be easily modified to be virtually undetectable in metal detectors and other security equipment. The State Department is particularly concerned that Defense Distributed's proposed export of undetectable firearms technology could be used in an assassination for the manufacture of spare parts by embargoed nations, terrorist groups, or guerrilla groups, or to compromise aviation security overseas in a manner specifically directed at U.S. persons. And both the government and the public have a strong interest in curbing violent regional conflicts elsewhere in the world, especially when such conflict implicates the security of the United States and the world as a whole. Now, of course, these arguments were ludicrous when made, right? Because if you think about the difficulty in obtaining and I know it's not that difficult, a 3D printer, the materials, the CAD files, getting it done, putting it together, because you have to assemble it afterwards. If you think about the difficulty in all of this, the easier answer is just to get a regular gun for your assassination. Like, they're talking about countries where AR-15s literally grow on trees, right? Because so many bullets have been planted in the ground. I think that's how that works. They're talking about countries, not AR-15s, AK-47s. Sorry, AK-47s like just sprout up like pineapples or whatever. And they're worried about someone 3D printing the Liberator, right? Which is that was the all 3D printed gun. Well, all except for the metal firing pin that you need to install, which is a giant nail, because you still have to have metal to actually set off a bullet. But, you know, I mean, but these, of course, were ludicrous concerns. If a political assassination is going to occur somewhere around the world, the availability of a 3D printed gun does not make it more likely. It's unreliable. There's no way you would entrust an assassination attempt to a 3D printed gun. That would be ludicrous. You would use any other method, like a grenade, a handgun, a rifle, maybe a knife, a sword, who was it? That Japanese guy got assassinated by a katana. You'd be like Obama and just drone strike him, maybe. Anyway, the then director of the Office of Defense Trade Controls Management, Lisa V. Aguirre, concluded that unrestricted export of the Defense Distributed's CAD files would result in the production of plastic firearms that are fully operable and virtually undetectable by conventional security measures. Now remember, the conventional security measures at this time include, backscatter radiation scans that you go through at airports, right? Where they tell you to literally not have a piece of paper in your pocket because the millimeter wave detection device can allegedly pick it up. It also measures your penis. So there's that. But yes, the backscatter millimeter wave detection devices already are in production at this time, if I'm not mistaken, and they're saying that You know, these conventional security measures, how do we know? They just put that plastic gun wherever. Let's see. And that they're used to commit terrorism, piracy, assassinations, or other serious crimes. Piracy. That's right. The Somali pirates who take over trade ships or whatever, they're worried that they're going to 3D print the guns. Wait, I'm sorry. Like, they don't need to 3D print a gun to pirate. Like, that's the dumbest thing. They already have guns and they're on a boat. They're on a big boat with a bunch of other guys with guns, and then they go on to a different boat. There's no metal detector. It's like, oh, sorry. I know you're pirating and you're going to take over our boat, but I'm going to ask you to leave your AK-47 on the ship. Don't worry, you have plastic. Like, what is this? Government's so stupid. Piracy, assassinations, or other serious crimes. Zero. By the way, zero crimes. Zero assassinations. I think zero murders with 3D printed guns since their creation. Zero. But that's a big number. That's per year. Zero per year. I know. When you just say a number out in the void, it doesn't sound like as much. But when you point out that it's annually, it magnifies, right? Because this has been going on since 2012, allegedly. So that's now 8 years of zero, and that's a whole lot more than just zero. Look, I don't know who pirates. Maybe it is Russians. Who knows? Just zero guns, though. Just zero 3D printed guns used to murder people so far. Was there an attempt? There might have been an attempt. I can't remember. Would cause serious and long-lasting harm to the foreign policy and national security interests of the United States. That efforts to... Yep, they're going to be mad at the CAD file, not the guy who shot him. That efforts to restrict the availability of these articles to the enemies of the United States would fail. They failed already. Like, I don't have those CAD files. I used to have them on an old phone. I had those CAD files. Actually, you're allowed to have them in the United States, so that's kind of a joke. But yeah, they put them up, and I immediately downloaded them several years ago. I remember I was at work. I had a little touch screen planner. I think it was an HP. It was pretty cool, and I used that thing to download these stupid files because I was like, government's gonna take these away. Gotta have them, right? That the proliferation of weapons and related technologies would contribute to a more dangerous international environment. Can I point out that, like, these CAD files, anybody can make a CAD file. Like, this isn't some special thing that you need. I mean, they made the Liberator because one guy, Cody, decided to sit and do it. But this isn't special. Like, it doesn't mean it's not the only design that works. It's not the only design out there. It's not the only place that you can get them. These files are, you can't stop it. You can't stop it. They exist. And they're available literally. You can go find them right now. You just can't find them on Defense Distributed's website. That the export would undercut the domestic laws of nations that have more restrictive firearm controls than the United States. Foreign relations with those nations would suffer. Has it? Has it, though? The Honorable Robert L. Pittman denied Defense Distributed's motion for preliminary injunction, noting that Defense Distributed's avowed purpose is to facilitate global access to and the collaborative production of information and knowledge related to the three-dimensional printing of arms. Yeah. And that such activities undoubtedly increase the possibility of outbreak or escalation of conflict. Undoubtedly, but unprovenly. Like they just said it, so it was. And are the type Congress authorized the president to regulate through the AECA. Austin Hartless says, having worked on ITAR related stuff before, the US government doesn't even like people taking pictures of ITAR stuff. If I take a picture of something ITAR and post it online, I could be charged with a felony if I recall. That's great. It's lovely, isn't that? That's not a restriction on your speech, though. That was a joke. The Fifth Circuit affirmed, finding that the State Department's stated interest in preventing foreign nationals, including all manner of enemies of this country, from obtaining technical data on how to produce weapons and weapon parts, constitutes a very strong public interest in national defense and national security. In April 2018, so that was just a ruling on the preliminary injunction and then an appeal of that ruling. In April 2018, the federal government moved to dismiss Defense Distributed's claims in the Texas litigation, reiterating that what was at stake was the United States' ability to control the export of weapons, a system of laws and regulations that seeks to ensure that articles useful for warfare or terrorism are not shipped from the United States to other countries or otherwise provided to foreigners without authorization, where beyond... Yes, the irony should be plainly apparent. We sell guns and missiles to all of these people all the time, right? All the time. I mean, we sell guns, missiles, planes, ships. We sell tanks. We sell armored personnel carriers. We sell all of this stuff to all of the people that are concerned all of the time. Way more than 3D printers, just so we're clear. Where beyond the reach of the U.S., they could be used to threaten U.S. national security, U.S. foreign policy interests, or international peace and stability. Later that month, the parties reached a tentative settlement agreement. So here we go. So they settled. Pursuant to the settlement, which was not signed until July 29th, 2018, the Department of State changed course. Again, this is before, this is after Trump was elected. Oh yeah, there we go. Abandoning its prior regulatory and litigation positions and allowing the private defendants, Defense Distributed, Second Amendment Foundation, and Con Williamson, Cody Wilson? Who the hell is Con Williamson? Let me see. Who's Con Williamson? Author at Liberty Park Press. Who is this guy? Who's this guy? I don't know who that is. I don't know if that guy is... Maybe that's the same... Maybe he was involved. It looks like he's Liberty Park Press, straight shooting news. So he must have also wanted to distribute the files. I've never heard of him, so I don't know. No offense to Con Williamson. I thought the judge just boomered Cody Wilson. To publish on the internet CAD files for the automated production of 3D printed weapons. The federal government specifically agreed, among other things, to publish a notice of proposed rulemaking and final rule revising the United States munition list that would allow the distribution of the CAD files, to announce a temporary modification of the U.S. munitions list, to allow immediate distribution while the final rule was in development, and to issue a letter to Defense Distributed and other defendants advising that the CAD files are approved for public release and unlimited distribution. So the department who oversees this decided that they would change the rule. They would settle, they would change the rule and permit the production of these files. The federal defendants also acknowledged and agreed that the temporary modification and letter, quote, permits any United States person to access, discuss, use, reproduce, or otherwise benefit from the CAD files. The announcement of the temporary modification and the issuance of the letter were to occur on or before July 27, 2018. No findings of fact or other statements are provided in the settlement agreement that address, much less invalidate, the federal government's prior analysis regarding the likely impacts of publication on national security or world peace, or that otherwise explain the federal government's change of position. Here's a question for the court. So what? So what? How many settlements out there require a finding of fact to change the position of one of the parties? This is an insane statement inside this ruling. There don't need to be findings of fact or other statements provided in the settlement. One of the parties decided to change course, and they came to an agreement. That's all settlement generally is. This happens whenever you settle after a lawsuit has been filed. You take your strongest position on either side of the suit. You go after your opponents full on. Then when you reach settlement, it's like, well, I mean, there were no findings of fact to show why they weren't injured from being bludgeoned in the face. Well, who cares? The person who was bludgeoned in the face is fine with it. The person who did the bludgeoning is fine with it. We don't care what their findings of fact were. They've decided on how to settle this out. That's gone. We're down to Jack. I don't think I'm actually down to Jack, but I'm down to Jack. As for what's out, God, I hate this caramel sort of smell. All right. Got a headache, hoping Jack will fix it. Ugh. February whiskey review, we'll see. We'll see when that is. I've got to find a good one to do. Okay, on May 24th, 2018, the Department of State published a Notice of Proposed Rulemaking, NPRM, that implicated the technical data at issue in the litigation. The NPRM proposed an amendment to the ITAR to, among other things, remove certain Category 1 items, primarily small caliber weapons and their related technical data, from the USML, thereby lifting the requirement to obtain a license for their export. So this is May 24th, which is before that July 27th proposal. Although the NPRM did not explicitly mention 3D printed firearms or their related technical data, approximately 12% of the comments received in response to the NPRM did, and all of them opposed lifting the license requirement. Oh, well, I mean, that means we shouldn't do it. The public comment period ended on July 9th, 2018. The settlement agreement was made public the following day. The temporary modification was published, and the letter to the private defendants was issued on July 27, 2018. Temporary modification contains an assertion that the DDTC, quote, has determined that it is in the interest of the security and foreign policy of the United States to immediately modify Category 1 of the U.S. munitions list to exclude the technical data at issue in the Texas litigation. The public comments opposing exclusion were not considered by the agency when it issued the temporary modification and letter. So there you go. They didn't care. 3 days after the temporary modification was published, 8 states and the District of Columbia filed this lawsuit, alleging that the federal defendants' conduct was ultra vires and in violation of the APA and the 10th Amendment to the United States Constitution. So again, here we have states stating that the federal government engaging in federal regulation is a violation of their state's rights. I mean, I don't know how they get there. The list of things you can actually make a 10th Amendment argument on anymore are insane. After the 14th Amendment, we have gone and pared down states' rights just progressively, where it's down to basically just custody and specific state laws. But other than that, federal government has supremacy over almost everything. And almost everything implicates some sort of Commerce Clause thing. I mean, making a 10th Amendment argument is different. They're difficult on its face. Here they're saying that federal regulation over the import and export, which is plenary authority of the United States, not of individual states, somehow violates their states' rights. That's nutty. That's nutty. None of these states have tried to make it illegal to distribute the CAD files in their states. I mean, they got an injunction for one or two of the states, but none of them have done that. None of them have passed a law trying to make them illegal. They'd get hammered if they did. And they know it. So what state right could possibly be violated here? In response to plaintiff's motion for preliminary injunctive relief, federal defendants justified the deregulation of the CAD files, along with the delisting of other items within Category 1 of the USML, by pointing to a Department of Defense determination that the items, quote, do not provide the United States with a critical military or intelligence advantage, and, quote, are already commonly available and not inherently for military end use. After an expedited hearing, the court found that plaintiffs had shown a likelihood of success on the merits of their APA claim, insofar as the temporary modification resulted in the removal of one or more items from the U.S. munitions list, that plaintiffs had shown a likelihood of irreparable injury if an injunction did not issue, because Defense Distributed had announced its intent to make the CAD files downloadable from its website on August 1st, 2018. The private defendants now assert that they published the subject CAD files to the internet immediately upon receipt of the letter and the issuance of the temporary modification. The publication does not change the following analysis. And that the balance of hardships and the public interest tipped sharply in plaintiff's favor. I mean, why? Why is what public interest? I mean, not a speech interest, right? How is this in the public interest at all is a really good question. The federal defendants were enjoined from implementing or enforcing the temporary modification of the USML and or the July 27th letter, and were required to preserve the status quo ex ante as if the motion had not occurred and the letter had not been issued. So there you go. You're not allowed to have your little lawsuit settlement. Can't do it. In the context of the state's challenge to the issuance of temporary modification and letter, the federal defendants produced and supplemented the administrative record on which the decision to issue the temporary modification and letter was based. Plaintiffs do not concede that the record as supplemented is complete or that defendants' various claims of privilege are proper. Okay. Plaintiffs now seek an order invalidating the temporary modification and letter under the APA and permanently enjoining the federal defendants from removing the computer files at issue from the USML unless and until they comply with the governing procedural requirements. The federal and private defendants oppose plaintiffs' motion and request judgment in their favor. So the states are arguing, in essence, that the federal government didn't follow the proper procedure in doing what they did. Therefore, they can't do it until they follow the proper procedure. So this is one of those interesting sort of things. Jurisdiction. Both the federal and private defendants challenged the court's jurisdiction over this matter. Federal defendants argue that the states cannot meet prudential standing requirements. That's a good question. Private defendants argue that the issuance of the temporary modification and letter are committed to agency discretion by law and not subject to judicial review under 5 U.S.C. 701 and 22 U.S.C. 2278. That listing on the USML is a political question over which the court lacks subject matter jurisdiction. The claims are barred by the Tucker Act. Defendants also incorporate by reference arguments made in the preliminary injunction context regarding Article 3 standing and this lawsuit being an impermissible collateral attack on the outcome of the litigation in the Western District of Texas. Those arguments are again rejected. So they just, yeah. What they're saying is, so the defendants or the plaintiffs didn't like the result of a lawsuit in a different district court. So they filed this lawsuit to invalidate another court's decision. Because that's what we've got here, right? This is filed in district court in Washington State. Okay? In federal court in Washington State. And they're overturning the Western District of Texas litigation. The settlement in a different jurisdiction. Again, you don't get to see this very often. What's the Tucker Act? I don't know what the Tucker Act is. I could look it up real quick. Tucker Act. This is going to be very exciting. Under the Tucker Act of 1887, the U.S. government waives its sovereign immunity as to certain kind of claims. So that's the Tucker Act. I don't know how it bars them. Let's see. The act extended the original Court of Claims jurisdiction to include claims for liquidated or unliquidated damages arising out of the Constitution. Permits 3 kinds of claims against the government: contractual claims, non-contractual claims. I'm not going to be able to tell you how this implicates the Tucker Act. That's going to be in their argument. I'll have to look it up for a different time, maybe as we look at the appeal. But I'm not familiar. That's pretty specific. Zone of interest. The question of standing involves both constitutional limitations imposed by Article 3 of the U.S. Constitution and prudential limitations imposed by the judiciary to limit the exercise of federal jurisdiction. To present a justiciable case or controversy under Article 3, plaintiffs must demonstrate an injury in fact that is fairly traceable to the actions of the defendants and that will likely be redressed by a favorable decision. The prudential limitations are, quote, founded in concern about the proper and properly limited role of the courts in a democratic society. The prudential requirement at issue here is that a plaintiff's grievance must arguably fall within the zone of interest protected or regulated by the statutory provision on which the claim is based. I know this is a thick jurisdictional discussion, and the judge is going to just write it in the way that favors jurisdiction because he wanted to deal with this case. I mean, that's how it goes. Should they have standing? No. Why would states have standing over the outcome of a lawsuit that solely concerns a dispute between private citizens and the federal government over a federal regulation involving foreign commerce? I mean, it makes no sense that states would have standing in this just on its face, but the judge is going to get there. Tucker says, so by this logic, could any state government now sue the feds to overturn a plea bargain or feds to overturn a state plea deal? This is ridiculous and a huge opening for tyranny. Well, it's not, this isn't precedental yet. This does not set precedent, as this is still a lower court ruling. We'll have to see what the appeals court says. The zone of interest is a standing requirement of general applicability, but the zone of interest of a statute for purpose of obtaining judicial review of administrative action under the generous review provisions of the APA is fairly expansive. The test, quote, is not meant to be especially demanding in the APA context, and the Supreme Court applies, quote, the test in keeping with Congress's evident intent when enacting the APA, that's the Administrative Procedures Act, to make agency action presumptively reviewable. Plaintiffs need not establish a congressional purpose to benefit them through passage of the underlying statute. They need simply have interests that relate to and are not inconsistent with the purpose implicit in the statute. The Supreme Court has, quote, always conspicuously included the word arguably in the test to indicate that the benefit of any doubt goes to the plaintiff. So there you go. The AECA, quote, was intended to authorize the president to control the import and export of defense articles and defensive services in furtherance of world peace and the security and foreign policy of the United States. In keeping with the goals of the statute, the federal government has, in the past, justified subjecting the CAD files at issue to ITAR's export licensing scheme based on their characteristics and functionality, which make them especially dangerous to U.S. national security and foreign policy interests. The agency properly focused its analysis on the fact... Now, see what this judge is doing here? Look at this. Right there. The judge has gone ahead and given his political opinion on the matter. That should be pretty clear, right? The agency properly focused its analysis on the factors specified in the AECA and deemed it important to keep plastic, undetectable firearms out of foreign hands where they were not subject to the U.S. laws and controls. I mean, I guess. The agency's focus on exports, national security, and world peace does not, however, mean that the state's domestic interests are unrelated or marginally related to the AECA's purpose. How? How's that? The State Department found that the firearms generated by the subject CAD files can be easily modified to be virtually undetectable, and metal detectors and other security equipment could be used in assassinations or terrorist activities specifically directed at U.S. persons, and could lead to violent regional conflicts that implicate the security of the United States. Notice that's the United States. And again, he's not pulling... They're citing to an argument that was made in a lawsuit that was resolved unfavorably. Like, they should be embarrassed to bring this citation in. Given that the CAD file, like, I can't even express if you as a lawyer brought the argument in to court with the citation to another jurisdiction, okay, to a lower court from another jurisdiction that settled the issues out in a way that is inconsistent with the argument that you raised, you might get backhanded by the judge, right? When the judge goes and reads the case and says, wait a minute, I mean, they made these arguments, but they settled in a manner that's inconsistent with the argument. If you brought that in to your argument, like that's bad legal writing. Given that the CAD files and the resulting weapons can be transported undetected virtually anywhere in the world, I mean, these same impacts would likely arise within the United States, even if the plastic weapons are manufactured abroad. I'd like to see you take a Liberator on an airplane. Like, good luck. They detect tortillas. They look at my microphone. These aren't all metal objects. My mic has a lot of metal in it, but they detect food. You can see the screen. They're not detecting only metal in the X-ray machines. Let's see. So they're saying that, you know, it will likely impact the states somehow. The state's interest in curbing violence, assassinations, terrorist threats, aviation, and other security breaches, and violations of gun control laws within their borders are at least marginally related to the interests protected or regulated by the AECA. No, they're actually not. I don't know how else to say it. The state and federal interests, while not identical, no, they're not identical, and they're not aligned, and they are inconsistent, because the federal interest in regulating the export of these CAD files, regulating the export overseas of the CAD files, it has nothing to do with regulating I can take this CAD file and I can hand it to you. I can mail it to you. I can, I can do all sorts of stuff. I just can't post it on the internet because that would make it so that a foreign entity can come in and grab it. So no, the state's interests are not involved in the exportation of arms. That is not part of the state's interest, or the importation via foreign commerce. That's not states' interest. That is squarely and solely within the authority of the federal government. And you let a state try and regulate the import and export of something from a foreign nation and watch them get slapped down by supremacy clause every single time. They can't do it. Because a state's grievance arguably falls within the zone of interest protected or regulated by the AECA, there's no judicially imposed limit on the court's exercise of jurisdiction in this manner. This is going to be one of their major appeals points. They're going to say this is poorly reasoned. I mean, whether the appeals court or not will agree, is up to the appeals court. But they're going to hit this really hard, because if they hit this, then the court doesn't have jurisdiction, and they would have to try and file a motion in the Western District of Texas or through an amicus brief or something like that. So this would be a knockout victory if they can overturn on the standing argument. Agency discretion and judicial review. The private defendants argue that this court lacks jurisdiction over plaintiffs' APA claims because the APA does not apply to the extent that agency action is committed to agency discretion by law. The AECA expressly commits one type of decision to agency discretion, namely the decision to designate an item as a defense article or defense service. The decision at issue here, however, is the removal of an item from the U.S. munitions list. So I hope you guys caught what just happened. All right. So the act in question, the administrative act that they're challenging, commits one type of decision that the agency makes, just one, only one type, to agency discretion, which would put it outside of the bounds of the court. Okay? Outside the bounds of the court, because it's fully within the agency's discretion. Fully. And that is the decision to designate an item as a defense article or a defense service. The judge is arguing, though, here that the removal of an item is not part of the decision to designate an item as a defense article or defense service. So, there you go. That's what they're arguing. And that's what the judge says. I mean, that's the judge's thing. Look, it's just the decision to designate it, but the decision to remove it isn't part of the decision to designate it. I mean, to me, that sounds like the decision to undesignate it. Plaintiffs are challenging that the federal defendants' failure to comply with statutory procedures and or to consider certain congressionally specified factors when making removal decisions under the ACA. Congress did not expressly make such removal decisions unreviewable. So there you go. Even absent a statutory bar to judicial review, certain agency decisions have traditionally been considered wholly discretionary and beyond review. They don't even need this, though, because it's expressly beyond review. To be sure, the AECA confers broad discretion on the president when determining whether to add or remove items from the USML, but that discretion is not unbounded. Congress has imposed both procedural and substantive benchmarks to guide the agency's action. In order to honor the, quote, basic presumption of judicial review embodied in the Administrative Procedures Act, and to, quote, give effect to the command that courts set aside agency action that is an abuse of discretion, the Supreme Court has read the Section 701A2 exception for action committed to agency discretion quite narrowly, restricting it to those rare circumstances where the relevant statute is drawn so that a court would have no meaningful standard against which to judge the agency's exercise of discretion, and has generally limited the exception to certain categories of administrative decisions that courts traditionally have regarded as committed to agency discretion, such as a decision not to institute enforcement proceedings, or a decision by an intelligence agency to terminate an employee in the interest of national security. But the interest to designate or undesignate a weapon on the United States munitions list is apparently in the interest of national security, which is, remember, that's the argument. that this is in national security interest, that's not good enough. The procedural and substantive requirements at issue in this case are clearly stated, and whether the agency complied with those requirements can be judicially evaluated without fear of treading on any matter that implicates agency expertise, involves a complicated balancing of factors, or has been traditionally regarded as beyond judicial review. The court finds that the process through which defendants removed items from the USML in July 2018, defendants' compliance with the standards furnished by the AECA, and the adequacy of the agency's analysis of and explanation for its decision are subject to judicial review. So this one is crazy. The adequacy of the agency's analysis of and explanation for its decision is subject to judicial review. So a judge in Washington state is going to review the adequacy of an executive agency, of their internal analysis and then their explanation. That's how a judge is going to do that. With no expertise in the field of foreign policy or United States munitions or anything like that, this judge is going to review the sufficiency of their analysis and their explanation. So that's great. Political question. The private defendants also argue that the regulation or deregulation of defense articles or services under the AECA is a political question that is non-justiciable under the separation of powers doctrine. It should be. It really kind of should be. Remember, Obamacare is non-justiciable. Right? Basically. That's pretty... I shouldn't say that, but that's basically what John Roberts wrote in his decision was, the court is not here to save us from our political decisions. So he upheld the individual mandate. So, you know. But this, which is an agency decision, that's not. This argument fails for much the same reasons as the agency discretion judicial review arguments. While the decision to include an item on the USML or to grant or deny an export license for a listed item is statutorily excluded from judicial review and or requires an exercise of discretion within the agency's expertise, whether the agency complied with clear procedural requirements and considered factors Congress deemed relevant when removing an item from the USML is neither a political question nor one committed to the agency's discretion as a matter of statute or case law. Tucker Act. Finally, the private defendants assert that the Court of Federal Claims has exclusive jurisdiction to render judgment upon any claim against the United States founded upon any express or implied contract with the United States. Plaintiffs seek to invalidate agency action under the APA because it violates the procedural requirements of the AECA or is arbitrary and capricious. These claims are statutory, and as plaintiffs point out, the Tucker Act has no application in this context. Private defendants abandon this argument in reply. So there you go. So they initially argued that the Tucker Act. So their argument must have been that that the settlement is an express or an implied contract under the meaning of the Tucker Act, and therefore this court lacks jurisdiction. But when they replied to the opposition, they abandoned the argument. So there you go. Administrative Procedures Act claims. The APA authorizes judicial review of final agency action and provides that a reviewing court shall hold unlawful and set aside agency action, findings, and conclusions found to be arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with the law, in excess of statutory jurisdiction, authority, or limitations, or without observance of procedure required by law. Plaintiffs argue that the federal government's efforts to immediately remove items from the USML through issuance of a temporary modification and letter were not in accordance with law and were without observance of procedure required by law insofar as the State Department failed to give 30 days notice to the Congressional Foreign Relations Committee specified in 22 U.S.C. 2778 F1. Plaintiffs also seek to invalidate the decision to allow the CAD files to be published on the internet on the ground that the temporary modification violates the limitations on federal power imposed by the 10th Amendment. Okay. Finally, plaintiffs argue that the agency action was arbitrary and capricious because the agency failed to consider the factors identified by Congress and because the delisting is not supported by substantial evidence in the administrative record. I know these are thick arguments. They're really, really specific, and I hate them. They also just lack a common understanding of how things work. The AECA requires that the president or his designee periodically review the items on the USML to ensure that export controls are warranted. The result of the review must be reported to Congress, and the department, quote, may not remove any item from the munitions list until 30 days after the date on which it has provided notice of the proposed removal to the Committee on International Relations of the House of Representatives and to the Committee on Foreign Relations of the Senate. Federal defendants argue that the congressional notice requirement does not apply because the CAD files at issue here are not specifically enumerated on the USML and are therefore not items for purpose of 2778F1. This argument was rejected at the preliminary injunction stage, and the court sees no reason to reconsider its decision. So, interestingly, the CAD files themselves aren't actually listed on the USML. So, now we get even crazier because they're not even listed. And the court's argument is that they're not allowed to delist them. This is just stepping on all your freedom right there. It's stepping on it. The president has the power to designate defense articles and defense services and to control their import and export in furtherance of world peace and the security and foreign policy of the United States. The articles and services, i.e. items, so designated constitute the USML. Category 1 of the USML includes all firearms up to .50 caliber, and all technical data required for the design, development, production, manufacture, assembly, operation, repair, testing, maintenance, or modification of such firearms. Through the CJ process, the Department of State specifically determined that the subject CAD files are subject to the export controls of the ITAR. Department of State argues that its decision to immediately allow the unlicensed export of previously regulated items does not trigger the congressional notice requirement because the temporary modification did not deregulate a whole group or category of defense articles described in the USML, such as non-automatic and semi-automatic firearms to caliber .50 inclusive. This argument conflates category with item. As described in the statute, the USML is a list of items designated by the president as defense articles and defense services. Rather than generate an exhaustive list of every individual article or service that is subject to export control under the AECA, Department of State opted to populate the USML with generally descriptive categories. Those categories describe actual items, however, and it is those items that are defense articles and defense services subject to the export control. The congressional review and notice requirements specifically apply to items, not categories of items. The Department CJ regulation further confirms that it is the removal of a particular article or service, an item rather than a category, that triggers the review and notice requirements. The department describes the CJ procedure as a means of resolving doubts, quote, as to whether an article or service is covered by the USML, and to seek redesignation of an article or service currently covered by the USML. Immediately after the reference to redesignation, the regulations reiterate that the department must provide notice to Congress at least 30 days before an item is removed from the U.S. munitions list. Given the language, structure, and purpose of the statute and implementing regulations, the court finds that the attempt to revoke the listing of an item previously covered by the USML through the issuance of a temporary modification, thereby lifting all export controls under the AECA and ITAR, triggers the congressional notice requirement of the statute. Now, let's just all pause for a second and not let the federal government off the hook here. They could moot this case and end this immediately if they just provided 30 days notice to Congress anytime in the last, 4 years. 2 years of this case, 2 years before when Trump was elected and they started changing their tone. But specifically in the past 2 years, if they just provided notice to Congress 30 days and then they could remove the item. That's all they have to do. Just give notice to Congress that you're removing the item. That's it. Given the language, structure, and purpose of the statute in implementing regulations, the court finds that an attempt to revoke the listing of an item previously covered by the USML through the issuance of a temporary modification, thereby lifting all export controls under the AECA and ITAR, triggers the congressional notice requirement of the statute. It is undisputed that Congress was not notified prior to the removal of the subject CAD files for the USML. This procedural failure cannot be rectified by providing congressional notice 30 days in advance of making the temporary removal final. Temporary modification implemented the removal immediately without waiting for the proposed rule to become final, without giving Congress notice and an opportunity to exercise its oversight role, because the removal to which the states object occurred as of July 27, 2018. A subsequent notice is obviously not timely under the statute. To the extent the federal defendants are relying on 22 CFR 126.2 as authority for the temporary modification, its use of that procedure to immediately redesignate an item that was previously covered by the USML without congressional notice violates the governing statute. It is beyond dispute that a federal regulation cannot empower the government to do what a federal statute prohibits it from doing. So, hold on, where were we? Right here. So they need to give subsequent notice. They need to give notice and then 30 days later remove it. Like, that's all they have to do. They still can. This is such a weird suit. Court finds that the temporary modification of the USML to allow immediate publication of the previously regulated CAD files constitutes the removal of one or more items from the USML. Just a second. Give me just a second, guys. I'll be right back. All right. Sorry about that. Oh, where were we? Okay, the court finds that the temporary modification of the USML to allow immediate publication of the previously regulated CAD files constitutes a removal of one or more items from the USML without the required congressional notice. Because the agency action was without observance of procedure required by law, must be held unlawful and set aside under Section 706 of the APA. So there you go. So that temporary removal is not allowed. They got to do a real one. Breck, that's a good question, man. They said the CAD files are not listed. How could they give notice of removal of an item that's not listed? 10th Amendment claim. As part of the settlement agreement in Texas litigation, the federal defendants agreed that the temporary modification that would be issued on or before July 27th would permit any United States person, including the private defendant's customers and members, to access, discuss, use, reproduce, or otherwise benefit from the technical data contained in the CAD files at issue. Plaintiffs argue that this provision exceeds the limits imposed on the federal government by the 10th Amendment in that it conflicts with and presumably abrogates state laws restricting certain persons from possessing, manufacturing, owning, and or using firearms in general, or 3D printed firearms in particular. Plaintiffs therefore argue that the temporary modification must be invalidated as otherwise not in accordance with the law under the APA. Sure. Okay. I guess because they said any United States person can do this. Well, of course they can. Of course they can. They can access, discuss, use, reproduce, or otherwise benefit from the technical data. That doesn't mean that they can manufacture, possess, or own a firearm. They can own, access, and use and benefit from the technical data. So this is a ludicrous argument. Let's see. Plaintiffs therefore argue that the temporary modification must be invalidated, otherwise not accordance in the law under the APA. Both the federal and private defendants have, at various times during this litigation, disavowed any intent to alter or in any way impact existing prohibitions or limitations on the possession of firearms, and the federal defendants recognize the continuing viability of state law and gun control measures. Plaintiffs find no comfort in these statements, given the plain language of the operative temporary modification and letter. So yes, a letter sent to a defendant is going to overrule state law, they're suggesting. A review of the notice of temporary modification letter shows, however, that neither communication expressly permits any United States person to use the CAD files or 3D printed firearms, nor do they contain a reference incorporating the settlement agreement or the promises set forth therein. Without assistance from the parties, the court declines to determine whether a contractual provision regarding the intended meaning of a promised future statement would have any effect on state law. Of course it wouldn't, or be otherwise enforceable when the statement, when finally issued, contains no language regarding the subject matter. So that was just a stupid argument. Thank God the court made one good decision here. Let's see. Arbitrary and capricious. Plaintiffs allege that the federal defendant's decision to allow Defense Distributed to upload to the internet CAD files containing 3D printing instructions for the manufacture of undetectable weapons was arbitrary and capricious because the State Department failed to consider the factors set forth in the AECA, failed to offer an explanation supported by substantial evidence in the administrative record, and or has asserted justifications that are pretextual. In determining whether agency action was arbitrary and capricious, the court's scope of review is narrow and focused on determining whether the agency examined the relevant data and articulated a satisfactory explanation for its decision, including a rational connection between the facts found and the choice made. In order for the court to be able to determine whether the agency has acted within the bounds imposed by the governing statute, the agency is required to disclose the basis for its action, making the findings necessary to support the decision, and produce an administrative record that substantially supports those findings. The federal defendants, citing 22 CFR 120.3b, argue that only items that are provided a critical military or intelligence advantage belong on the U.S. munitions list, and that a multi-year interagency review process led to the determination that firearms up to .50 caliber do not satisfy that standard. There are a number of problems with this argument. First, the regulation cited states that articles or services that provide a critical military or intelligence advantage shall be included on the USML. Items that fit that description must be on the USML, but they are not the only items that can be included. Thus, an agency determination that small caliber firearms do not provide critical military or intelligence advantages does not explain why those previously controlled items were removed from the list. Because if they determine that they don't provide a critical or military or intelligence advantage, then it's discretionary to put them on the list. They're not mandatory to be on there, so they determined that they don't need to be on there because they don't fit this in. That's the reasoning. They gave it to you. Second, Congress granted the president and his designees the discretion to remove an item from the USML in light of certain circumstances and factors. Congress directed the agency to consider how the proliferation of weaponry and related technical data would impact world peace, national security, and foreign policy. The State Department essentially concedes that, despite the specified statutory consideration, it evaluated the export controls on small caliber firearms only through the prism of whether restricting foreign access would provide the U.S. with a military or intelligence advantage. Because the delisting was not based on consideration of the relevant factors within the scope of authority delegated to the agency by the statute, it must be invalidated under the APA. I mean, let's see. So to consider how the proliferation and related technical data would impact world peace, national security, and foreign policy, the State Department says it evaluated the exported controls on small caliber firearms only through the prism of whether restricting foreign access would provide the U.S. with a military or intelligence advantage. So therefore, they did. I don't know of a proper analogy. To give for this. They didn't specifically say these things. Okay. Okay. Third, given the agency's prior position regarding the need to regulate 3D printed firearms and the CAD files used to manufacture them, it must do more than simply announce a contrary position. Quote, the requirement that an agency provide reasoned explanation for its action would ordinarily demand that it display awareness that it is changing position. The agency need not always provide a more detailed justification than what would suffice for a new policy created on a blank slate, but sometimes it must when, for example, its new policy rests upon factual findings that contradict those which underlay its prior policy. It would be arbitrary or capricious to ignore such matters. In such cases, it is not that further justification is demanded by the mere fact of a policy change, but that a reasoned explanation is needed for disregarding facts and circumstances that underlay the prior policy. That's citing FCC versus Fox television stations. Until April 2018, the federal government regulated technical data related to the design and production of weapons using a 3D printer because the data and weapons pose a threat to world peace and the security and foreign policy of the United States. Some of its concerns related specifically to the undetectable nature of a gun made from plastic, because they could slip through conventional security equipment. The State Department feared that they could be used in assassination attempts, hijackings, piracy, and terrorist activities. Other concerns related to the probability and ease of manufacturing process would allow terrorist groups and embargoed nations to evade sanctions, repair weapons, restock arms supplies, and fuel violent conflicts. These are the old arguments, and they're just so at odds with what 3D printed guns actually are. Right? Repair weapons. Oh yeah. Yeah. You're just going to go 3D print some repair parts for your AK-47. I mean, you kind of can. It's not going to work very well. It doesn't function in that way. Both aspects of the technical data at issue would, the State Department feared, subvert the domestic laws of nations with restrictive firearms controls, impairing the United States' foreign relations with those nations. Overall, the Department of State concluded that the worldwide publication of computerized instructions for the manufacture of undetectable firearms was a threat to world peace and the national security interests of the United States and would cause serious and long-lasting harm to its foreign policy. Against these findings, the federal defendants offer nothing. No analysis of the potential impacts of removing CAD files for 3D printed firearms for the USML. No response to the public comments raising concerns about such a removal. No acknowledgement in the NPRMs of its change in position with regard to the CAD files, and no justification in the temporary modification, the letter, or the administrative record for the change. Big footnote. The private defendants point to a PowerPoint presentation made at an additive manufacturing symposium February 2014 and a law review article written by their former counsel that same year as support for the agency's 2018 decision to remove the subject CAD files from the USML. The law review article merely raises constitutional arguments against the regulation of 3D printed guns and is seemingly unrelated to any justification the agency has offered for its action. I mean, they offered it. The symposium presentation includes 2 slides related to 3D printed guns, one displaying a picture of a 3D printed gun courtesy of Cody Wilson, and another including text stating that export controls offer no benefit to U.S. manufacturing or national security. There's no indication that the agency actually relied on this document when issuing the temporary modification in 2018. In fact, it tacitly concedes that it did not because the multi-year review upon which the decision was apparently based focused on small caliber firearms generally, not 3D printed guns specifically. Just as importantly, the slides do not reflect consideration of the factors Congress intended the agency to consider to constitute a reasoned explanation for disregarding the agency's prior findings regarding the impact of 3D printed weapons on world peace, national security, and foreign policy. Oh boy. I hate this decision. The federal defendants argue that the agency appropriately evaluated whether import and export restrictions on small caliber firearms were warranted and that the results of the multi-year interagency review to apply to the 3D printed guns and the technical data related to them. The only parts of the administrative record cited in support of this argument are the NPRMs issued by the Departments of State and Commerce regarding the delisting of certain items in Category 1 of the USML. A review of those documents shows that the goal of the proposed revision is to limit Category 1 to only those items that provide the United States with critical military or intelligence advantage, or, in the case of weapons, are inherently for military end use. Wait. Let me read this again. The only parts of the administrative record cited in support of this argument are the NPRMs, the proposed rule modifications, issued by the Departments of State and Commerce regarding the delisting of certain items. A review of those documents show that the goal and purpose of the revisions is to limit Category 1 to only those items that provide the United States with critical military or intelligence advantage, or, in the case of weapons, are inherently for military use. Okay. The descriptions of what will be covered with the revised Category 1 vary in the NPRMs. Department of State asserts that the revised Category 1 will cover only defense articles that are inherently military or that are not otherwise widely available for commercial use or commercial sale. Department of Commerce describes Category 1 items under the amended USML as those which are inherently military and otherwise warrant control on the USML or possess parameters or characteristics that provide a critical military or intelligence advantage to the United States are almost exclusively available from the United States. Okay? The revised Category 1 will no longer cover small caliber, non-automatic, and semi-automatic firearms. Revised Category 1 will no longer cover commercial items widely available in retail outlets and less sensitive military items. I mean, they are providing the reasoning right here. And the revised category, the proposed changes are based on an interagency review. These statements are merely descriptions of the changes proposed and the process used, not an analysis of or justification for the changes. The Department of Commerce goes on to say that it believes that unless an item provides a critical military or intelligence advantage to the United States or is generally unavailable at retail outlets for civil and recreational activities, the burdens of subjecting U.S. manufacturers to the obligations of the ITAR are not warranted by any proportionate benefit to national security or foreign policy objectives. So there again, they're discussing the national security and foreign policy objectives. They're just using slightly different language. Whatever the merits of this analysis with regards to the rimfire rifles, pistols, and other popular shooting implements specifically mentioned in the NPRMs, it does not provide a reasoned explanation for the action with regard to the CAD files and 3D printed weapons at issue here. So they're fine with everything else? Wait, so the court is fine with all of the other stuff, just not the CAD files and 3D printed weapons that aren't listed? Jason of the Great Awakening says, I'm not clear on the distinction between CAD files for a 3D printed firearm and NSA having published a large volume of cyber warfare tools open source last year. Both tools and plans of value only in the right skilled hands. Because the NSA did it is one of the main things. JXDBX says, hose mad. Some enterprising lady figured out wearing a motion tracking suit and making a 3D model boob bounce on a campsite was profitable. All the 3D PD hate for her getting top 5. This might be the best timeline. Yes, he's talking about the Chatterbait waifu. The Chatterbait waifu is hilarious and yeah, it's blowing it out. Good job. I mean, this is crazy. So they're fine with all of these other things, but they're not. They didn't get enough of a reason for these two things, which are only incidentally included. They're not specifically included. Less than 2 months before the NPRMs were published, the State Department had taken the position that 3D printed weapons pose unique threats to world peace, national security, and the foreign policy of the United States. The agency's specific concerns regarding the proliferation of these weapons are well documented in the administrative record. The NPRMs neither display an awareness that the agency is changing its position with regards to the data files, nor provide a reasoned explanations for new policy that necessarily rests upon factual findings that contradict those which underlie its prior policy. The agency has simply abandoned, without acknowledgement or analysis, its previous position and has sub silentio found that the delisting is consistent with world peace, national security, and U.S. foreign policy, despite explicit recent findings to the contrary. I don't know that they found that to the contrary. They just stated it. We're vastly overstating their initial findings. Again, since there is no data on this. There is zero data that this will occur. In addition, there are no findings and no evidence in the administrative record that the CAD files at issue here were widely available before the agency abruptly deregulated them on July 27, 2018. I mean, they've been available. Never mind. They didn't show it. That's a failing. That's a failing, right? They didn't show it. They didn't add the evidence of where they could be found in the record. Because it is an arbitrary and capricious to ignore the contradiction in these circumstances, the agency action must be invalidated. The court finds that the agency action is arbitrary and capricious in two independent respects. First, the agency failed to consider the aspects of the problem which Congress deemed important before issuing the temporary modification letter on July 27th. Second, the agency failed to identify substantial evidence in the administrative record explaining a change of position that necessarily contradicts its prior determinations and findings regarding the threats posed by the subject CAD files and the need to regulate the same under the AECA. Because the agency action was arbitrary and capricious, it is unlawful and must be set aside. Because the agency action must be invalidated on other grounds, the court has not considered whether the agency's justifications were pretextual or whether such a finding would warrant invalidation under the APA. They just didn't bother to get to the other thing. Motion to dismiss. The private defendants incorporate by reference a motion to dismiss that was denied almost a year ago. Having offered no reason to reconsider the prior ruling and no explanation for the delay in seeking reconsideration, the motion is denied. Personal jurisdiction. Defense Distributed argues that the court lacks jurisdiction over its person. Such a defense can be and has been waived. Although Defense Distributed asserted a personal jurisdiction defense in its answer, it omitted it from the motion to dismiss it filed on October 11th, 2018, and has therefore waived the defense under Federal Rules of Civil Procedure 12H1A. So that's apparently misstep. The court apparently has jurisdiction because even though they asserted it in an answer, they did not assert it in the motion to dismiss. And that is part of the problem with procedural motions, right? If you don't assert your defense, you can waive it. So there you go. First Amendment justification for agency action. Private defendants argue that the CAD files are protected speech under the First Amendment and assert that the files were removed from the USML in order to avoid constitutional problems. The agency, however, has not relied on the First Amendment as justification for its action, and neither the court nor the private defendants may supply a basis for the decision that the agency itself did not rely upon. So there you go. First Amendment violation. The private defendants again assert that the restrictions on their ability to publish the files constitute a prior restraint that is presumed to be unconstitutional, and that the regulation should be subject to strict scrutiny. Whether or not the First Amendment precludes the federal government from regulating the publication of technical data under the authority granted by the AECA is not relevant to the merits of the APA claims plaintiffs assert in this litigation. Plaintiffs allege that the federal defendants failed to follow prescribed procedures and acted in an arbitrary and capricious manner when they issued temporary modification and letter authorizing the immediate... The court is saying, fuck your rights. Right here. Right here, they're just saying it. The State Department has not attempted to justify its action as compelled by the First Amendment, nor have the private defendants shown that their First Amendment interests are a defense to plaintiffs' claims or a talisman that excuses the federal defendants' failures under the APA. Screw your rights. I mean, your First Amendment rights trump the Administrative Procedures Act. Guaranteed. Your First Amendment rights trump the Administrative Procedures Act. Because if the acts inherently violate the First Amendment, then it doesn't matter what justification exists. If your First Amendment rights are implicated in the regulation of the speech, then it doesn't matter at all that the proper procedure wasn't followed because it implicates the First Amendment rights of the citizenry. The judge just said, nah, screw it. The presumptive remedy for unlawful agency action is vacatur and remand. Plaintiffs also seek an injunction preventing the federal defendants from again issuing a temporary modification purporting to deregulate the subject CAD files with no warning. Plaintiffs have not shown that the harm they fear is likely to occur. However, there is no indication that the federal defendants are poised to immediately modify the USML as soon as their previous efforts are invalidated or otherwise inclined to ignore the procedural and substantive requirements of the AECA discussed in this order. Conclusion. For all of the foregoing reasons, plaintiff's motion for summary judgment is granted in part and denied in part. The July 27, 2018 temporary modification of Category 1 of the United States Munition List and letter to Cody R. Wilson, defense distributed in the Second Amendment Foundation, were unlawful and are hereby vacated. Defendants' motions for summary judgment are denied. So there you go. That's it. That's how it goes. That's a poor decision. Especially the part where he just ignores the First Amendment argument. Says, yeah, well, sorry. Your First Amendment argument isn't at issue here. I mean, it is. It is. They have a First Amendment right, maybe, to publish those articles, right? Like the CAD files. They may have a First Amendment right to do so. The state action is preventing them from doing so. They're in a court with jurisdiction over the matter, and the court just ignores the First Amendment argument. So that's that. So anyway, we started covering this case, oh my God, back, I think, when it was filed. And just in the hubbub of last year was a whirlwind, man. I don't even remember most of it. I missed it. This was back in November. This has been appealed. This decision has been appealed, I believe, by both the federal and private defendants. And so I will try and find the appeal documents and see how that's going. It's big news. Question of whether or not you can publish a drawing on the internet. I mean, what constitutes a technical drawing, right? Like at some point, is a picture of an AR-15, is that a technical drawing? What about all of the 3D printed parts, right? Are those individual pictures? Because it's got like the little spring coil or whatever, the plastic coil. Would those be a technical image subject to it? We have no idea. I have a thumbnail on one of my videos that is, I believe it's the laid out Liberator parts. Is that an illegal publication? We don't even know. Don't we have a First Amendment right to talk about this stuff? Won't know because the judge just decided to ignore it. So there you go. That's what we got. There are some super chats to read and justice chats, but I'm going to wrap this one up kind of early tonight. And I'll do a little bit of Twitch, but not super late because I have a bit of an early morning tomorrow. I have some stuff I have to take care of. So I will be reading the super chats and justice chats, and then we'll wrap up the show, and then come join me on Twitch for a little bit of Doom action, and then we'll call it a night. Oh boy. All right. The Agrolith says, why you no love boomer stamps? It's not that I don't love them. I just haven't had time to go find them. That's all. Nobody says, Romversations, though, you fathead. Thumps. Romversations will either be tomorrow or Wednesday. I'll announce it. Bad Vibe says, we sell to every army except the Salvation Army. Nobody says, I couldn't drink anyways. I like Tylenol too much. Ew. Skeet Neat says, Nick, the space between my thigh and the family jewels smells like a flat IPA. How do I fix this? Oh, dear Christ. Shower yourself in bleach. Ace Wolf 75 says, in all caps, Fox News reporting that Rush Limbaugh just died. We all believe you. Ace Wolf. Deep Fried Lettuce says, was at district court today. Did you know that at least 8 people were willing to send scans of their passport and license to Barry McCockiner? Silverwolf0080 says, have you ever had a client so stupid they got themselves convicted when they would have otherwise gotten off? Yes. Well, I mean, sort of. It led to plea agreements. But yes. Mario Carter 13 says, claims 10th Amendment violates 5th. Double jeopardy. This doesn't actually violate double jeopardy. That's double jeopardy is very, very specific, and it's not as broad as people think. Andrew War Snowboard says, Black History Month's been great so far. Black's History Month been great so far. Black's is delicious barbecue. Enjoy it quite a bit. Okay. Night of Hopex says, U.S. government invented nukes, software that lets you track and kill anyone, and a laser that will sear your nuts off through your window. But us publishing common knowledge online is a threat to someone, so F us, I guess. Huh. Funny how that works. Yep. Night of Hopex says, I don't know if these retards realize this or not, but you can mill a gun out of a block of plastic that's sturdy enough to withstand the pressure with a regular drill press, a hacksaw, and some files, faster than printing it. How does this even matter? It doesn't. That's the crazy thing. 3D printed plastic guns are not useful. They're a novelty. They're not strong enough. Like you said, anyway, I won't reiterate it. Egg Falafel says, could a judge be sued for malpractice? Or is that just what the appellate court is for? That's what the appellate court is for. I mean, judges can be impeached. and they can be disciplined and sanctioned by a disciplinary board, just like lawyers can. So, all right, guys, let me hit this intro or outro. And yeah, thanks for joining me tonight. It was a little bit of a different sort of live stream, but I really wanted to cover this because it was something we covered before. I missed it, and when I read the order, I skimmed the order. I couldn't believe it. I couldn't believe that that was the decision that they came to. So thanks for hanging out with me tonight. Twitch will be on in just a couple minutes after I go put on a thought top because I am melting. And we're going to play a little bit of Doom. So come hang out there, and we'll see you all soon. All right? Have a good night. Peace. Peace.
Pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an art bag, a bow, more a love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Planning tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all planet folks from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed, so pour out a glass for the tea post on Twitter as we hear Lost Planning tonight. From the white shores of Nan to the hills of Glenlivet, there's no one